This is the video deposition of Megan Chanell. Would you please swear in the witness?
Megan, can you hear me?
I can.
Would you raise your right hand, please? Under the penalties of perjury, do you swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much.
Good morning, Ms. Chanell. My name is Charlie G. I'm one of the attorneys that represents LLOYD Kessler, the plaintiff in this matter, a public records case filed against the Oregon Department of Transportation. Can we start with, will you state and spell your full name for the record?
Yep. My name is Megan Chanell, MEGAN CHANNELL.
All right. And have you ever had your deposition taken before?
No, I have not.
Okay. Well, just some ground rules, especially now in the day of Zoom. So everything we're saying is being recorded by the court reporter and also on a video. And the court reporter will create a written transcript. And so since there's a written transcript that's being created, one thing we have to be careful of is not to talk over one another. And I'm terrible at that. So if you talk over me, I'll try and politely remind you to not talk at the same time I'm talking. If I start to talk over you, you don't even have to be polite. You can just say, hey, stop. Because it's kind of weird because we're not in the same room, so we don't have those kind of social cues. The second is to answer out loud. And instead of saying like, or or nodding or shaking your head, to say the words yes or no. That way we create a better record. The third is you're under oath. And so the testimony here today carries the same weight as testimony in court. And if this case went to trial and your testimony in trial were to differ from your testimony here, that'd be something we would point out. Do you understand?
Yes.
Great. So what is your current job title?
My current job title, I'm the Rose Porter Project Director with the Oregon Department of Transportation.
All right. And how long have you had that job?
Since March of 2019.
And what are your job duties in that job?
I'm responsible for overseeing the project's design and construction. So I'm responsible for overseeing the ODOT staff and the consultant staffs for that work.
And as part of your job duties, reviewing and responding to public record requests?
I'm responsible for overseeing the teams that respond to public records requests.
Okay. Are you involved in reviewing and responding to public records requests?
Yes.
All right. And who is a member of that team that responds to public records requests?
It really depends on what the public record request is, kind of the nature of that request. We have different technical team members that I would look to help provide those responses.
And in overseeing that team of people that respond to public records requests, have you ever reviewed the Oregon Attorney General's Public Records and Meetings Manual?
I have not.
Have you received any sort of training in responding to public records requests?
I have received some training, yes.
And what sort of training was that?
It was through ODOT with the public records staff out of headquarters.
And as part of that training, did you receive any written materials?
I don't remember.
Okay. And do you happen to recall if you possess any written materials produced by ODOT regarding how to respond to public records requests?
I also don't know. I don't recall.
Okay. Other than that ODOT public record request staff training that you just mentioned, have you received any other training in how to respond to public records requests during your time with the state of Oregon?
I have not.
And other than any written material that we just mentioned that may have stemmed from that training, have you received any other sort of written material in your, I'm sorry, let me start that over because that just turned into a mess. Other than any written material received from that ODOT staff training, have you ever received any other written material from the state of Oregon regarding how to respond to public records requests?
I don't believe so.
All right. And so we're here about a public record request made by Alan Kessler on December 6th, 2019. Is that your understanding?
Yes.
Are you the person most knowledgeable about that public records request within the team in your project within the state of Oregon?
Yes.
All right. Is there any other person that you can think of that may have different knowledge than you, or do you think you have a pretty comprehensive knowledge about that public records request?
I believe I have a pretty comprehensive knowledge of the request. The only other person would be Laura Rojas, who is the public records staff involved with this.
Gotcha. And that predicted my next question. So other than you or Laura Rojas, can you think of anybody else that was involved in working on this public records request made by Alan Kessler on 12/6/19?
Yeah, we have a team of consultants from AECOM. They're contracted with us. And so
Sorry,
they're
I'm sorry. The team,
AECOM, so it's AECOM.
thank you.
All right,
sorry.
so I'm sorry, you can go ahead and finish your answer then.
Sure. So AECOM are the consultants that were preparing and responsible for preparing the environmental documentation and including the response to comments. And so the AECOM consultant team would have also been involved in preparing and responding to the public records request.
Gotcha. So, and what is AECOM? Is that a private company?
Yes, they're a private consulting firm.
Gotcha. And you worked with AECOM regarding this public records request?
I did.
Do you recall who within AECOM that you worked with?
The main point of contact was Louise Kling.
And who is Louise Kling within AECOM?
Louise Kling is the project manager on the AECOM side for the environmental review for the Rose Quarter project.
All right, so on December 6th, 2019, I'm sorry, let me back up. And you'll have to forgive me because I'm kind of wrapped up in my own life all the time. What is the Rose Quarter project?
The I-5 Rose Quarter Improvement Project is focused on improving operations and safety in the Rose Quarter area. And so it's adding auxiliary lanes to I-5 between Interstate 84 to the south and Interstate 405 to the north. And it also involves constructing a highway cover over I-5 that provides new community space over I-5 and new multimodal improvements across I-5, reconnecting local streets. So those are the main components of the project.
Cool. All right. Sounds like you're the person to ask about the Rose Quarter project. You know a lot about it. I unfortunately don't. So Alan Kessler made a public records request on December 6, 2019. Is that your understanding?
Yes.
And as part of this case, you completed a declaration signed June 30th, 2020. It's called the Declaration of Megan Chanell in support of defendant's motion for summary judgment or partial summary judgment. And I'm going to kind of use that as a lot of framework here because it provides a good chronology. So and maybe what I'll do is, are you familiar with that document?
I'm familiar with it, but if we're referencing it, it would be helpful if it were up on the screen so that we're looking at the same thing.
Let's see if I can get my technical know how to do that. All right. All right, we may need to go off the record to share screens. Can we go off the record real quick?
We're off the record. We're back on the record.
All right. Let's see here. All right, are you guys seeing my PDF there?
Yeah, I can see it.
Okay, good. All right. So is this the declaration you're familiar with?
From what's shown on the screen, it'd be helpful if you could scroll down. And can you restate the date that you said this declaration was from? I guess that's where I'm getting confused.
Yeah, so this was your first declaration dated June 30th, 2020.
Okay.
All right. So it looks to me that the language of the public records request is stated in your declaration was please provide in their native formats the full data, tagging, coding, notes, and/or summaries of the public comments received during the public comment window on the I-5 Rose Quarter project in 2019. If this information is stored in a database, please provide a full export thereof. Is that your recollection of the wording of Alan Kessler's public records request?
Yes, it is.
All right. And to your knowledge, was this Alan Kessler's first public records request regarding the Rose Quarter project?
That I don't know.
Okay. Had you ever worked on any other public records requests from Alan Kessler?
I don't recall.
How about, was there other public records requests related to the Rose Quarter project that you worked on prior to Mr. Kessler's request?
I don't recall. There have been other records requests and don't remember if they were prior to this one.
Okay. So, but there had been other public records requests related to that Rose Quarter project?
Correct.
And then moving down on 12/26/19, it says ODOT initially denied Kessler's December 6th request. Is that your understanding?
It is.
And were you involved with the denial of his request on December 26, 2019?
Yes.
All right. And were you the person that made the decision to deny it?
It was based on advice that I had received.
It was based on advice you had received, as in legal advice or non-legal advice?
Legal advice.
All right. And I don't want to know anything about the content of that advice, but do you recall who gave you that advice, as in the name of the attorney?
I don't recall.
Okay. Was it an attorney within the Oregon Attorney General's office? Do you recall?
It would be from the Department of Justice.
Department of Justice. Okay. So, and then it's my understanding that the request was denied as being that because the documents were incomplete or unfinished. Is that true? Or is that correct?
The documents were still in incomplete form in coordination with our federal partners at the Federal Highway Administration.
Gotcha. And is it your understanding when a public records request is denied, the denial needs to include the statute that the exemption is based on? Is that, do you understand that?
I do understand that.
Okay. And was a statute provided to Mr. Kessler in his denial?
I don't know.
All right. Have you ever heard of a statute ORS 192.335?
I'm not.
So did you have any role in providing the exemption to Mr. Kessler?
Can you state that again?
That was a bad question. Thank you for asking me to state it again. Let me move backwards a little bit.
Okay.
When you got advice from the attorney, and I don't want to know about the content of the advice, but did you get that advice in an email or was that a conversation?
It was a conversation.
Gotcha. So I'll represent to you that Mr. Kessler was provided a denial in writing from Laura Rojas, who I understand you're not Laura Rojas, and she said the documents won't be provided. They are incomplete per the exemption found in ORS 192.335. So I'm going to represent that to you. From my understanding, you had no part in developing that exemption that was provided to Mr., or not developing, but coming up with the exemption that was provided to Mr. Kessler in his denial?
I was part of the,
Hold on. I'm gonna object to the form. I believe it misstates her prior testimony. You may answer.
thank you. I was part of the conversation, but I was not the one defining what the exemption was. I was purely stating that the information was incomplete and still in formation with our federal partners.
Do you know where Ms. Rojas got the ORS 192.335 statute from?
I don't.
So in your opinion, other than that statute or that exemption that was cited, was there any way that Mr. Kessler's public records request was defective, as in on the face of the request, was it, impossible to respond to?
I'm gonna object to the form and to the extent it calls for an opinion. She's here for the recipient witness to this matter, but you can answer if you know.
Can you restate the question?
So in your opinion, other than, the exception that was provided or exemption that was provided to Mr. Kessler, was his public records request defective in any way? As in, was it impossible to respond to?
The same objection. You may answer.
I don't believe it was impossible.
Okay. I mean, and let me follow up then. So did he make it through proper channels?
I recall that he did submit it through our formal public records request process, yes.
All right. And to your knowledge, was there, other than the exemption that was provided, was there any other reason that his public records request could have been denied?
Not to my knowledge.
Counsel, just the inquiry on my part is, this ultimately is moot in that your client, ODOT changed their position and the Attorney General, you took it up to the Attorney General and they made some ruling. It's not the subject of your litigation.
I'm sorry, the timing of the records is not the subject of our litigation?
No, I mean, ultimately, you've got the records in terms of you can ask the question you want to ask.
Great, thank you. So this group that you're involved in looking at Mr. Kessler's public records request that ultimately denied it, who was in that group?
Sorry, can you?
I'm going to object to the form that to the extent that it calls for legal attorney-client communication.
I didn't ask what they talked about. I asked who was a member of the group.
You can answer.
And Charlie, I want to make sure I'm understanding your question correctly. The member of the group in the conversation around the denial, that.
So you testified there was a group of people involved in the initial public records request denial. Was that correct?
Correct.
Who were the members of that group involved in that? Just their names.
Given that this was back in 2019, I'll do my best to recall, but it was myself, Laura Rojas, legal, and I don't remember who else was there, to be honest.
So it was you, Laura Rojas, some legal person, I'm assuming a lawyer, is that correct?
Correct.
And were there other people involved? You said you couldn't recall who, but were there other people?
Someone from AECOM, Louise Kling from AECOM may have been involved.
And you don't recall who that was from AECOM?
It would have been, I just said it would have been Louise Kling from AECOM.
Okay. And how did this group communicate? Did you communicate all in person and by phone, or were there writings?
I don't recall.
you don't recall like at all, or you,
I'm sure it was in varied forms, but I don't recall specifically how we communicated.
okay, when you say various forms, what could those various forms have been?
In-person conversation, phone conversation, email.
And have you ever searched for any emails that may have originated from these conversations?
I personally have not.
And in the written conversations, was the legal person who was involved always CC'd on those emails?
I don't know.
Okay. And if the legal person, I'm sorry, and if there was emails, would Luis Kling or somebody else from AECom have been CC'd on those emails?
It's possible.
And so were any of the in-person meetings about this matter, were they ever on official calendars, as on your calendar or Laura Rojas's calendar?
That I don't remember.
All right, so it looks like 12/27, Mr. Kessler appealed the denial to the Attorney General. Is that your understanding?
That's my understanding, yes.
All right. And it sounds like you had a conversation with the Attorney General's office after that point. Is that your understanding?
Yes.
All right. And do you recall when that conversation happened?
Late 2019, early 2020.
And what happened after you talked to the Attorney General's office?
We ended up providing the responsive draft documents.
Gotcha. And so you said that this phone call happened with the Attorney General's office in late 2019 or early 2020. Do you use a calendar within your role in your job?
I do.
All right. And is it your habit to mark down meetings that are going to happen or that are scheduled?
It is.
Do you recall setting up a meeting with the Attorney General's office?
I recall having the meeting with the Attorney General's office.
But you don't recall scheduling the meeting?
It was so long ago, I don't recall whether I set it up or not.
Gotcha. So I'm sorry. So we kind of got went on a little branch there. So after you talked to the Attorney General's office, what happened then?
We then issued the most recent draft documents responsive to the request.
Okay. So then you no longer consider the documents exempt from a public records request?
Correct.
Right. And how was that determination made within your sphere, right? I mean, was there meetings about that issue?
There were conversations about that issue, yes.
All right. And who were those conversations among?
It would have been.
Hold on a second. I object. Asked and answered, but you can answer again.
Would have been myself, Laura Rojas, and a member of the legal team. So in this case, the Attorney General.
Let me go back and clear up the objection. I asked her about conversations surrounding the denial, but we have just moved on to the provision of the documents. So I'd like to ask my question again and see if it still draws that objection, but that question was never asked and answered. Do we have a disagreement on that, Mr. Karpinski?
You do. I think it's the same question. It's the same conversation. You can ask away and she can answer again.
Okay, well, she's already answered it. If the objection is going to stand, we're talking about two different dates. You know, there's the request made on the 6th, the denial made on the 26th, and then after the Attorney General issues their opinion, there's another meeting. I was trying to find out who that group was. So, but that's fine. Your objection can stand. So
I think your summary misstates the evidence, but you
Okay.
can proceed.
Okay. So it's you, Laura Rojas, and some person from legal. Is anybody from ACOM involved in those conversations?
This conversation with the Attorney General, I don't recall.
Okay. So when you spoke to the Attorney General, did you send the records that may have been responsive to the public records request to the DOJ lawyer?
Hold on, object to the question calls for attorney-client communication. You don't need to tell him what you sent to the lawyer.
Fair enough. So, okay, so to reset our kind of line of question here. So after further conversation with the Attorney General, ODOT agreed to withdraw their claimed exemption. Is that correct?
Correct.
All right. So close this. And for some reason, I can't end my screen share. There we go.
We love technology.
During COVID, I've added so many monitors to my home office setup that it's just outrageous. Okay. All right, so now we have a second declaration that you provided in 19th of August 2020. Do you remember that declaration?
I do.
All right. So again, I'm just kind of using that as a framework. So paragraph 3, you say, as ODOT prepared its response and with the advice of counsel, we determined that the December 6th request did not ask for the public comments themselves or ODOT's substantive responses to the public comments. So was that the same counsel as before, I'm assuming, but let me know if I'm wrong.
Yes.
Okay. And then you say we determined. Who was the we? Was that you and Laura Rojas?
The same group that I've been stating, myself, Laura Rojas, with legal counsel.
Okay. So it sounds like a determination was made that the request made by Alan Kessler did not ask for the public comments or ODOT's responses to the public comments. Is that correct?
The public records request asked for the summary of public comments received, but it did not request the responses to public comments.
So it sounds like we can go here, we can see the full public records request language. It did request summaries, but it also requested full data, tagging, coding, and notes of the public comments. Is that correct?
The public records request says, please provide in their native formats the full data, tagging, coding, notes, and/or summaries of the public comments received during the public comment window.
Okay, and you said that it was your interpretation that he asked for the summaries, but not the full public comments or the responses. Is that correct?
My interpretation was that he requested the full data, tagging, coding notes, and or summaries of the public comments received.
Okay, and so I'm assuming a determination was made that full data didn't include the comments themselves?
It include, well, we did provide the full comments themselves
Okay,
in response, in the responsive documents.
okay, because I'm just looking here in this paragraph 3, determined the December 6th request did not ask for either the public comments themselves, but you did provide the public comments.
We did provide a copy of the public comments,
Okay,
but the writing of the public records request is the full data, tagging, coding notes, and or summaries of the public comments received.
understood. So, but it sounds like there's a determination that he didn't ask for the public comments, but you decided to provide them anyway. Do I understand that?
Correct, yes, we provided them.
Okay. And it sounds like there's a determination made that the public records request did not request ODOT's substantive responses to the public comments.
Correct.
And was there determination made to provide those as well?
The determination was based on the text of the public records request.
I understand, but did you provide the substantive responses to the public comments?
We did not provide the response to public comments as they were not part of the request.
Okay, but you did provide the public comments themselves,
Yes,
but you also didn't believe the public comments themselves were part of the public records request.
That's asked and answered. You can answer again.
the summaries of the public comments received was part of the public records request, which we provided in addition to the full text of all of the public comments received.
Okay, so even though Mr. Kessler didn't ask for the full text of the public comments received, they were provided to Mr. Kessler in response to his public records request.
Asked and answered. You can answer again.
Yes,
All right, but the substantive responses to the public comments were not requested as part of the public records response and were not provided to Mr. Kessler.
Asked and answered. You can answer again.
yes.
Okay. Why was it that the comments themselves were provided, but the responses weren't provided?
They provided the backup documentation for the summary of the public comments, which was the request.
Understood. The substantive responses to the public comments, did those exist at the time of the public records request response?
They were in an incomplete draft form in coordination with our federal partners.
An incomplete draft form of what document?
Of the public comment summary report.
Is that commonly called the CSR?
I guess I don't know whether it's commonly called the CSR.
That's okay. We'll just refer to it as a comment summary report then. All right. So at the time of the public records response, the substantive responses to the public comments were contained within a draft of that comment summary report. Who maintained that draft?
I was maintained by our consultant team at AECOM.
Okay. And were there any discussions about, well, let me scratch that. Prior to the denial of Mr. Kessler's public records request, were there any discussions as to what documents would have been responsive to his request?
Yes.
Okay. And
I'm just going to object to the line of question to the extent it calls for attorney-client communication. So,
I don't, all of my questions, I have no desire to find out anything
Well,
about
but-
attorney-client. Yeah.
but even the question, if you ask, were there discussions about this, and the discussions were with her attorney, that's attorney-client communication. So we're on a fine line. I'll take it question by question, but you're on a fine
Yeah,
line.
I mean, the existence of a communication is not necessarily privileged. The contents definitely are privileged. I don't have any desire to even touch that or toe that line. So I'm happy to have you keep objecting, and I'm happy to talk it through.
Right.
All right. So it looks then on January 16th of 2020, an initial provision was made to Mr. Kessler. Do you understand? Is that your understanding?
Can you restate the date?
The date is January 16th of 2020.
And on that date, I'm sorry, you're saying that what happened?
That there was an initial, the first provision of records to Mr. Kessler was made. Is that
That's
your
my-
understanding?
That's my understanding, yes.
All right. How did ODOT determine, I'm sorry, let me go backwards. Do you recall what document was provided on that date?
On January 16th.
Correct.
I don't recall off the top of my head.
Okay.
But
So it looks like there was the
I-
initial comment summary report as a PDF was provided to him on that date. Does that
Correct.
refresh?
yes, thank you. Sorry, this was so long ago. Thank you for refreshing my memory. It was the draft, it was a PDF of the draft summary of the public comments.
Gotcha. And how did ODOT determine that that document was responsive to his request? As in, do you have systems that you search, or is there like an institutional knowledge of the documents that exist? What was the process for determining that document was responsive?
The process was working with our AECOM team to pull the most recent document that would speak to the summary of public comments.
So you said it's the most recent document. Were there older documents that would have been responsive?
This was an iterative document, so there were prior versions.
And did those prior versions exist somewhere?
Yes.
And how does that work within your project? Is there are various different, like, say, drafts stored separately so they're not overwritten?
The drafts are stored kind of on a milestone basis.
What does milestone basis mean?
For this, like the consultant submittals to ODOT. So when I receive a document that's been prepared by the consultant, I save that draft.
And where do you save that? Like on a computer system?
Yes,
And how do you usually receive those drafts? Are they email attachments?
typically via email.
And so for any given document, you may have multiple drafts going back in time that you've saved. And we do that in legal work too, where you've saved each individual draft as it comes in. You don't just overwrite it. Do I understand that correctly?
I saved the official submittal of the document.
Do you save the drafts that had been worked on or sent to you prior to the official submittal?
Some remain in email and some get saved depending on the nature of the document.
All right. So which systems were searched to determine what documents were responsive to Mr. Kessler's public records request?
I don't know.
Did you have a personal role in looking for documents responsive to his public records request?
I was part of again, with myself, Laura Rojas, and the AECOM team.
So you, Laura Rojas, and the AECOM team searched for documents. Was a lawyer involved in that search?
I don't know.
Okay. So, and you testified you don't recall which systems were searched. Did you search your own email for documents responsive to Mr. Kessler's public records request?
I believe there was a request for emails to be searched.
As in you requested or somebody sent a request to you?
That request typically comes from our public records team.
Gotcha. Oh, I see. Okay. So you got a request to search your emails. That's your recollection?
There would have been a request submitted for my emails to be searched.
But you didn't do the actual searching, it sounds like.
Correct.
All right. And then you mentioned that you save drafts, like your own drafts. Is that correct?
I saved the formal submittals from the consultants.
Okay. And I may have asked you this already, but where do you save those? Like, is that on your computer? Is that on a server, on a network somewhere?
It's on my computer, but it's on the ODOT server. So it's on the ODOT server.
All right. And when going back to searching your emails, I wanted to clarify, I was talking about in response to the public records request, not the request for production. Was that your understanding as well? Your email was,
I guess, can you help make that distinction for me?
so on 12/6/2019, Alan Kessler submitted a public records request for documents in their native formats, the full data. I was asking about whether or not you or somebody else, to your knowledge, searched your emails for documents that may be contained within your emails responsive to that public records request before litigation was initiated in this case, as in that point when ODOT started responding to Mr. Kessler's public records request.
I can't speak to the exact timing of it, but I do know that there was a request to our IT to search for emails.
Council, can we take a break here for a minute? And Ms. May, is it possible to put us in a breakout room, or Dano, can you put us in a breakout room, or is it something we should do offline?
I could do it.
Okay.
All right,
We're
we're
gonna
gonna
take-
take like a 15-minute
10
break or so.
Is that good?
All right, are we back on the record?
We're back on the record.
All right, so we just took a break and you've consulted with your attorney. Is there any anything about your prior testimony you'd like to revisit or change?
No.
Okay, so just a few questions following up on where we kind of left off, or before we left off. So you mentioned that you had saved some drafts in a folder on the ODOT server. Is that correct?
Correct.
Do you remember what folder you would have saved drafts in?
The project folder.
Is that just like a main folder?
It's a folder on the ODOT server.
And is that what it's called, is project folder?
I don't know what the exact title of the folder is called.
Okay. How about on SharePoint? Would those drafts have been saved on SharePoint?
Some of the drafts may have been on SharePoint.
Okay, but not all the drafts?
The consultant managed the SharePoint system, so I can't speak to that specifically.
Gotcha. And you'll have to excuse my ignorance on this stuff. I'm not familiar with things like SharePoint. So so we were, before we broke, we were talking about, June 16th, 2020, ODOT produces its first production of public records response to Alan Kessler. Is that your understanding of where we were at?
Correct.
Okay, and we determined that it provided him a copy of the comment summary report as a PDF. Is that correct?
Correct.
All right. And where did the version that was provided to Mr. Kessler come from? As in, was that from ODOT? Was that from AECOM?
It would have originated from AECOM.
Okay. And what sort of document was that? Was that like a Word document that came from AECOM? Was it a PDF?
Word document.
Okay. So, but a PDF was provided to Mr. Kessler?
On January 16th, yes, a PDF was provided.
Okay. So, but fair to say that somebody turned it from a Word document into a PDF document?
Yes.
Okay. Again, you have to excuse my technical ignorance here. So, okay. And we talked briefly about what systems were searched and whether or not your emails were searched in the context of the public records request response, and then we took a break. Were your emails searched, to your knowledge, in response to the public records request?
I don't recall.
Okay. Was anybody's emails searched in response to the public records request, to your knowledge?
I don't recall.
All right. So the public records request involved the reviewing, summarizing, annotating, commenting on, coding of these public comments. Was there people within the project who worked on those tasks?
Object to the form. It misstates the nature of the public records request. There's no reference to commenting on.
I apologize. So the public records request references tagging, coding, or notes of public comments. Were there people who worked on tagging, coding, or making notes about public comments?
Yes.
All right, and who were those people?
That would have been AECOM, our consultant team.
Was there any state of Oregon employees who were involved with the tagging, coding, or taking notes of public comments?
The AECOM team led that effort. There may have been some ODOT staff involved in reviewing that material.
In reviewing the material that was produced by AECOM?
Correct.
And who were the ODOT staff that would have reviewed the material produced by AECOM?
That would have been myself for the submittals, as well as Jeff Buckland. And forgive me for my pause. This was, again, almost 3 years ago. April De Leon Galloway, those are the two. There may have been more, but those are the two that I believe would have had some sort of coordination around reviewing.
All right, so it's Jeff Buckland, and did you say April Galloway?
April De Leon Galloway.
De Leon Galloway, okay. Was Jeff Buckland asked if he possessed any documents responsive to Mr. Kessler's public records request?
I don't recall.
Was April De Leon Galloway asked if she possessed any documents responsive to Mr. Kessler's public records request?
I don't recall.
Does Mr. Buckland use email in his job?
Yes.
Does Ms. De Leon Galloway use email in her job?
Yes.
To your knowledge, was Mr. Buckland's email searched for documents responsive to Mr. Kessler's public records request?
I don't recall.
To your knowledge, was Ms. De Leon Galloway's email searched in response to Mr. Kessler's public records request?
Also don't recall.
All right. What sort of systems or software is used by ODOT or consultants or partners to capture public comments, review them, summarize them? Like, is there proprietary software that's used for that?
I'm gonna object to the form, but ODOT is a huge entity, so if you can limit your question to this project or
Absolutely,
limited
fair
in
enough.
time, something to that effect.
So say in the years 2019 through 2022 for the Rose Quarter project, what sort of systems or software were used by the Rose Quarter project or its consultants or partners to capture public comments and review and summarize them?
We rely on our consultant teams for that capture.
And do they use any sort of system or software to your knowledge?
I don't know.
All right, so it looks like there's at least one document that we're talking about right now that was identified as being responsive to Mr. Kessler's public records request, and it was the comment summary report, and it was sent to him on January 16th, 2020. You mentioned before that it contained, I'm sorry, scratch that. So that was sent to him on January 16th, 2020. Beyond you and beyond yourself, who else may have reviewed that document to determine the applicability to the public record request?
It would have been myself, Laura Rojas, and in consultation with legal.
Okay. So that version of the comment summary report that was provided on January 16th, was that the full version of that document?
It was the document that provided the summaries of the public comments.
Oh, I'm sorry. So that document came from AECom, correct?
Correct.
And when it came from AECom, it was in a Word version. Is that correct?
Yes.
When it came in the Word version from AECom, did that document contain anything within that document that then wasn't provided to Mr. Kessler on January 16th, 2020?
The document that we provided responded to the request for the summaries of public comment. So we provided the summary of public comment to Mr. Kessler.
Well, let me put it this way. Was anything deleted out of the document that was received from AECom before it was provided to Mr. Kessler on January 16th, 2020?
The responses to public comment were removed because they weren't responsive to the request.
They were removed so like somebody like again, forgive my ignorance. So like somebody sat down with the Word document and like deleted the stuff?
I don't know.
Did you sit down with the document and delete anything out of it?
I don't recall doing that.
Do you know if Ms. Rojas deleted anything out of the document?
I don't know.
But somebody removed text from the document that was received from AECom before it was provided to Mr. Kessler on January 16th, 2020.
The document that we created and sent to Mr. Kessler was what we believed was responsive to the public records request.
So you created a standalone document for Mr. Kessler to send him in response to his public records response?
We produced a document that was responsive to his records request.
By produced, do you mean created? Like not produced, like you gave it to him, but you created kind of this new document that had stuff taken out of it. Even though it existed in the original document. Do I understand that correctly?
The document that we produced to Mr. Kessler on the 16th of January included the summary of the public comments. It did not include the responses to the public comments.
But just so I understand, the document, when ODOT received it from AECom, that document did originally contain those responses.
Object to the form, I believe it's asked and answered.
I just want to make absolutely clear, yeah.
The version that we submitted, the PDF version that we submitted to Mr. Kessler included the summary of public comments in response to his public request.
Yeah, and that wasn't my question. My question is, ODOT got this document from AECom as a Word document, correct?
Correct.
And then that document, before it was provided to Mr. Kessler, somebody removed material from that document that was felt to be non-responsive to his public records request, and a new PDF document was created to provide to Mr. Kessler.
Yes.
And do you know who it was that removed that text and created the PDF?
I don't remember.
So again, this is not my normal gig. Is that a common practice in public records responses, to your knowledge, of removing text from a document that's non-responsive, not redacting? So like in the legal world, we redact, but just removing it and then creating a new document as a PDF to respond to a public records request?
I don't know.
Okay. Have you ever personally, in response to a public records request, removed text from a document before providing it to a public records requester?
I don't believe so.
Is it possible that you were the person who removed the text from this document that we're talking about today?
I don't remember doing that.
So you have no knowledge of it at all, or no memory of it?
No memory.
Okay. Is there any way was there any indication given to Mr. Kessler that text had been taken out of this document before it was provided to him in response to his public records request?
No, we were responding to, again, what was requested, which was the summary of the public comments, which we did provide on January 16th.
And do you know under whose direction a person may have removed that text? As in, did somebody tell somebody to remove the text?
Object to the form to the extent it calls for attorney-client communication. You can answer.
Okay.
Yeah, I mean, I don't think I can answer because it was based on our conversations.
Oh, I see. So it was based on legal advice that was received that text was removed. And I don't want to know about contents of legal advice. So let's just leave it there. It sounds like it was based on legal advice received. Is that correct?
The response to this public record request, yes, was in consultation with our legal counsel.
All right. So do you know what was removed from the version that was provided to Mr. Kessler? It sounds like it was the responses to the public records or to the public comments.
Yes, it was the responses to the public comments.
And was there anything else removed before it was sent to Mr. Kessler?
Not to my knowledge.
And has the version of the document created for Mr. Kessler been used for any other purposes?
I don't know.
Was the version that was created for Mr. Kessler saved separately somewhere on the computer system we've talked about?
I don't know. Yes, I would assume it's part of our public records documentation.
Counsel, I believe that's been provided to you both in Word and well, it was initially provided in PDF, ultimately provided in Word too.
Mr. Karpinski, are you talking about the version that was created for Mr. Kessler?
Talking about the responsive document that was produced on January 16th. It was then produced as a Word document to your client or to you, or I think to your client at the time. You weren't involved. I believe in the January 24th response.
Yeah. Hey, I know we just took a break. Can we take another 10-minute break? I know we're quite a bit ahead of schedule here. We have until noon. Is that okay?
Yeah.
All right, great. Let's pop back on maybe at 10:30.
Sounds good.
All right.
We're
thank
up
you.
the record. We're back in the record.
All right, welcome back. So we just took a break. Ms. Chanell, after it looks like you met with your lawyer. After meeting with your lawyer, do you want to change or edit any of your responses to the prior questions?
I don't.
Okay, so I want to do a quick housekeeping thing before we start again. So I wanted to make some exhibits. I wanted to make exhibit 1 your declaration of June 30th, 2020, which I showed you. And then for exhibit 2 to the deposition, your 8/19/2020 declaration. So how should I get those to the court reporter?
Actually, you can send those to me directly.
Okay.
My email is my name in reverse. It's up there on the screen. It's Marcia, MAYMARCIA @AOL.com.
Great. I'll CC everybody on that.
I appreciate it. Thank you.
So prior to the break, we were talking about the original provision of public records in response to Mr. Kessler's public records response that was made on January 16th, 2020. And it looks like, what was provided to Mr. Kessler differed from the original document in a way that, what I recall now, you have helpfully outlined in your second declaration where you highlighted the information that had been removed from that. Is that correct?
Correct.
Okay, so I'm going to just make that whole second declaration of yours that was made on 8/19/2020 and all of the exhibits with it, even though it's a little bit bulky. I'm going to make that exhibit 2 to your deposition. So we'll just have that. So on that exhibit 2, your declaration, let me share the screen here so everybody knows what we're talking about. 3. All right, do you see that?
Not yet.
Not yet. That's because I didn't hit share. So you think after 2.5 years I'd have this figured out. So, all right, do you see the declaration now?
I see the first couple lines of it, but it's hard to tell
Okay.
which one it is.
All right, so it is dated 8/19/2020. And it looks like if you go to paragraph 7, it says, after reviewing Exhibit 1 to the Kessler Declaration of the documents previously produced, I compared the text of the documents we had produced versus the text of Exhibit 1. I'm assuming when you say I, you mean I, Megan Chanell. Is that correct?
Correct.
All right. And so, and if we go down here, it looks like you have highlighted in yellow of Exhibit 1 to your declaration all the text that had been removed from the document that was sent to Mr. Kessler. Is that correct?
Correct.
Okay.
I'm gonna just object to that, the form of that question, because in her declaration, she states it's all that was removed from the document that Kessler had provided as Exhibit 1.
I understand. So is the information that's highlighted in yellow, Ms. Chanell, the information that was different between the document that you sent Mr. Kessler in response to his public records request and this other version of it that Mr. Kessler had independently obtained? It's not necessarily the difference between, or it doesn't necessarily mean that that was what was omitted by you. That was a mess of a question, and I apologize.
Can you restate that question?
I don't think I can restate that question, but I could maybe take it apart and restate a question. So Exhibit 1 to your declaration, which is this highlighted document, is the differences in the document that Mr. Kessler independently obtained and the document that was sent to Mr. Kessler in response to his public records request. Is that correct?
That is correct.
Okay. All right. And is what, so that was 1/16/2020. You sent that to Mr. Kessler. Do you recall getting an email from Mr. Kessler on 1/17/2020?
No.
Okay. Let me. All right, so here I've put up a email. Do you see that email?
I do see the email.
All right, do you recall receiving that email from Mr. Kessler?
Give me a moment to read the email.
Did we lose
We
Miss
may have-
Channel?
We may have lost her. She was, during our break, her internet gave out. And so I imagine she will be calling
Okay.
back in a second.
Yeah, we did.
All right. So we all just hang out and
We're off the record.
no problems. Let me know when we're all ready and keep
We're
going.
back on the record.
All right. So before your Zoom cut out, Ms. Channel, were you able to read this email?
I was partway through it.
Okay.
Give me one more second here. Okay, I've read it.
All right. Do you recall receiving this email?
I see that I'm on the CC list.
Okay. But do you have any independent memory of this email coming in?
Not of this specific email, no.
Okay. The question is, did this email spark any sort of impression that Mr. Kessler had the opinion that the public records request documents that he received were not complete or responsive to his, or fully responsive to his public records request? Do you recall any impression about that?
I see that his statement in the email indicates that his request was for the native version of the documents. And he got a PDF, so he was asking for an editable version of that.
And was he provided an editable version of the document he received as a PDF?
Yes, on January 24th, he was provided the editable version of that document.
And the editable version of the document he received was an editable version of the document that had been had the information taken out of it, right? The text.
It was the Word version of the PDF that was sent on January 16th, and that PDF was responsive to the document that we had that was responsive to his records request.
Gotcha. And then he also asked, are there any other drafts or marked up versions? Was he provided any other drafts or marked up versions?
He asked for the drafts or marked up versions in this email, but I don't recall that being part of his public records request.
Okay. So at some point then, did you learn that Mr. Kessler possessed a copy of this comment summary report that did contain those draft responses that had been removed?
At
Objection
some-
form. You can answer.
At some point, yes, through this process, we were made aware that he had independently obtained another version of the document.
And are you aware how Mr. Kessler got that document?
I'm not.
Okay. Do you know if there's ever an investigation within ODOT of how he got that document?
Not that I'm aware of.
Do you have any knowledge of Mr. Kessler or his internet IP address being blocked from the ODOT FTP site?
I do not.
What I would like to do, I know it's break heavy, but we're running ahead of schedule. Can we take another break so I can go over my notes? I think we're just about done.
Okay. We'll go back to our breakout room. How long do you
All
want?
right. How about until 11, 12 minutes?
Sounds good.
All
We're off
right.
the record.
So here we are, we're back from break. Ms. Channell, you've taken a break. You may have consulted with your lawyer. Thinking back, is there any of your previous answers you want to change or amend?
Nope.
All right. And then, so one housekeeping thing, I'd like to make that email from Alan Kessler, Exhibit 3. So I'll include that in that email of exhibits. And I just had a couple other questions and I think we're done. So it seems like for this document that had text removed from it, somebody sat down and removed the text. Why was that done? Like, why was the time taken to edit a document versus just provide a document that was overly inclusive in information? Do you know?
The document that we produced was again focused in on what was requested as part of the public records request, which again was the data, tagging, coding, notes, and summaries of the public comments. And so the document that was produced was responsive to that December 6th record request.
Understood, but it took somebody time to create that document then, right? To sit down and remove all that text. It took labor to do that.
Yes, so that the document that was produced would have required someone to produce it.
All right. Was there a reason why that was done instead of just providing the full document that was overly inclusive of information?
Again, the document that we produced was really in response to what was requested as part of the public records request, which again was the data, tagging, coding, notes, and summaries of the public comments. The information that was not included in the document that was produced for Mr. Kessler was the responses to public comments. And I don't see that as part of the public records request text.
So was that the reason then that they weren't part of the public records request? That was the reason that they were taken out? Not, I mean, were those responses like sensitive or some other reason that they would have been taken out, or is it just because they didn't respond to his public records request?
They weren't responsive to the public records request.
Okay, so that material wasn't like sensitive or anything like that.
Object. Well, object to the form. You may answer.
Again, the information, the response to the public comments was not responsive to the public records request.
Oh, I'm sorry. So that wasn't my question. What I was asking were those responses like sensitive or needed to be, again, forgive my ignorance, but needed to be protected or anything like that?
Object. I believe this asked and answered early on in the deposition, but you can answer.
The responses, the document, the responses to comments were still incomplete in draft form in coordination with Federal Highway Administration.
So, okay, so that didn't answer my question. Were they sensitive? As in, did they need to be protected or couched in any way?
Object to the form, depending on, sensitive may be calling for a legal conclusion, you may answer.
Would you mind defining what you mean by sensitive? I'm having a hard time being able to answer that.
I mean, so if those comments got out at that time, would it cause any sort of controversy or issue or you know, brouhaha?
Object calls for speculation. You may answer.
I think, again, the responses were in draft form and we wanted to make sure that we were consistent with our federal partners as we were putting that document together. Did
you coordinate with anybody at the federal government in regards to Mr. Kessler's public records request?
Not that I remember.
Did you have any conversations with anybody in the federal government about whether or not to include the responses to the public comments in regards to Mr. Kessler's public records request?
Not that I remember.
Were the responses provided to the federal government at all prior to the response to Mr. Kessler's public records request?
Prior version, we were working iteratively together in production of the responses to comments.
Okay. So do you agree that the full document, as in the document that it existed before it was edited, would have been responsive to Mr. Kessler's public records request? I'll just leave it there.
Charlie, at the end, you kind of garbled out. So what was
I'm sorry. So do you agree that the complete document, as it existed before it was edited, was also responsive to his public records request?
Object to the form, you may answer.
I guess I'm not entirely sure, Charlie, which document you're referring to, as there were prior drafts.
Okay, so the draft that was taken from ACOM and edited and then provided to Mr. Kessler, the document that was edited to provide Mr. Kessler his version of it, the document that was edited, would that have been responsive to his public records request?
Object to the form calls for legal conclusion. You may answer.
The document that we received from AECOM and then versus the document that we produced for the records request, the items that were removed were highlighted in that exhibit of my declaration, so that was very clearly identified. But the public records request was around summaries of the public comment, and the document that we produced was the most recent and most responsive document to his request.
It was the most recent document responsive to his request after it was edited to remove that material, correct?
Again, the document that we produced was responsive to what was requested as part of the public record request.
I know. So so I don't mean to veer off. So I do a lot of public records requests in my personal injury work. And when I get a public records request response back, I have the exact opposite experience, which is I get flooded with material that is just utterly unresponsive to my public records request. Was the original document containing the information that was ultimately removed also responsive to Mr. Kessler's public records request, even if it contained material that maybe was not responsive to it, as in it contained extraneous material?
Object to the form calls for legal conclusion. You may answer and ask an answer, but you may answer.
The document that you are referring to, Charlie, had the summary of the public comments as well as the response to public comments.
Mm-hmm.
So the document that it did include, yes, it did include the summary of public comments. The document that we produced was for the purposes in response of this public records request that asked for the summary of the public comments.
So the document that was produced was created solely to respond to Mr. Kessler's public records request.
The document that we produced was responsive to Mr. Kessler's record request.
I know it was responsive. But was it created solely to respond to his public records request?
Yes.
Wouldn't it have just been easier to give him the full document, even if it contained extraneous materials?
Object to the form of the question, argumentative.
You can answer.
Sorry, can you restate your question?
Wouldn't it have been more efficient to just provide him the whole document, even if it contained extraneous materials?
Object to the form of the question. You may answer.
We were, again, providing a document that was responsive to what the requester was asking.
I know, but my question, wouldn't it have been more efficient to just give him the original document and not just pull the stuff out that you didn't think was responsive?
Asked and answered. I mean, you've asked it 4 different times, Charlie.
And it hasn't been answered 4 different times. So
And
I'm asking, wouldn't it have been more efficient?
These
Yes or no?
answers, you don't like her question here. You don't like her answer, but
Well, I don't.
You can answer again if you wish.
I don't
Okay.
know. I don't know whether it would have been more efficient.
Okay, that's the answer. Thank you. So was anything added to the document before it was sent to Mr. Kessler, or was material just removed?
I don't recall, but I know that the exhibit that was provided in my declaration shows that information.
All right. Thinking back on your answers to my questions today, is there anything you would like to amend or change or edit?
No.
I think we are done here today. And I'm going to close it, but your own lawyer may have some questions for you. I don't know.
I have no questions. We'd ask for 30 days read and sign.
Okay. So we will order the original PDF only for us with the exhibits stamped, and I'll send those exhibits now by email.
We're off the record.